yourself on mute. Additionally, please bear with us if we have to pause for any breaks. Keith was diagnosed with COVID yesterday, but has graciously agreed to power through for us. Additionally, on your view, you can see that it shows view everyone. If you want to hide everyone, that may enable Keith's presentation to be larger on your screen. If you have any questions, you can put those in the chat bar and we'll be sure to get to those at the end of the meeting. So without further ado, I will hand it over to Keith.
Thanks, Myra. Good morning, everyone. It's certainly a pleasure to be in front of you today. Bear with me. For those that speak to me frequently, you probably are thinking to yourselves, Keith does not sound exactly like himself, and that's true. I'm in the midst of the 5-day self-isolation, but honestly, I'm feeling a lot better today than I have over the last couple of days. But from time to time, you may hear me cough, you may hear me mute myself. Just bear with me, and I appreciate everybody being here today. So without further ado, let me go ahead and get started. You know, we typically try to have this legal update, excuse me, every April, because that's generally the time of year that the legislature has either just completed its session or we're gearing up toward the end of the legislative session. And if you haven't muted yourself already, please do. When we last met, President Biden had just been inaugurated. We had a new administration, and really we were looking into the crystal ball. We were predicting what might happen in the next year, but without any assurance that things would play out the way that we saw them. Now that we're a year into things, we do have some items to report on to make everybody aware of, as well as some discrete, concrete legislation that's in the works that you may wish to know about. Last year, we were talking about extensions of the FFCRA and PPP and mandatory vaccine policies and COVID-19 business immunity. And I had planned to tell a joke about how those things are way in the rearview mirror now, but boy, is that not karma coming back on me. So what we will cover today, we're going to cover employment law at the federal level. The agencies that many of us are familiar with have been quite busy over the last year. The NLRB, the EEOC, the Wage and Hour Division, and the IRS. Oh my. We'll also talk about the Build Back Better legislation, because there are some under the radar employment law provisions in that legislation that everybody should know about. And although things did not work out the way I think the Biden administration planned by getting everything passed in one big bill, the approach now appears to be to pass bits of Build Back Better on a piecemeal basis. And the employment law provisions may be one of those things that Congress tries to pass before the midterms. There's also, if you did not hear about this last month, now a ban on mandatory arbitration of sexual harassment claims. We'll talk about that in just a moment. There's also some new EEOC COVID-related technical guidance that came out about 2 weeks ago that I want to alert everybody to, just so you know it's there and know that it's a resource that you can go to if you ever have issues come up that deal with caregivers, people who are missing work because their spouse, their child is sick and they need to care for them. We'll also do a Florida law update. And although most of the Florida laws that have passed in the last year have not really dealt with employment law issues, there are some, and one in particular that we'll talk about, House Bill 7. And then finally, we'll talk about what I think has been the busiest executive. I don't even know what court that's supposed to be for. So, excuse me. Well, we'll talk about the busiest agency over the last year, which is the National Labor Relations Board. And no surprise, the NLRB fluctuates. Its members fluctuate depending on who holds the presidency. And sometimes there's a majority of Republicans and sometimes there's a majority of Democrats on the board. It's a 5-person board. And presently it is chaired by a Democrat. There's a 3-2 majority of Democrats on that board. And the NLRB, as happens with every presidential administration virtually, seems to undo what the previous administration's board did. So I'll talk about the things that the current board is doing, such as trying to revert back to a previous standard for joint employers, for independent contractors. The NLRB is very active in trying to end mandatory arbitration, meaning arbitration agreements entirely, not just with respect to sexual harassment. And then probably the thing that will have the greatest impact on all of us here is that the board is making a conscious effort to expand what constitutes protected concerted activity. I don't know if Brad's on here or not, but Brad, go ahead and take a shot. This is a little drinking game he has. How many times can Keith say protected concerted activity in one of these legal updates? And we're going to talk about that a lot. Why do we talk about that? Because the greatest impact for non-unionized employers with respect to protected concerted activity is the impact it has on your handbook policies. And what we see from administration to administration is that policies that were previously perfectly lawful all of a sudden become unlawful. The board rules that this policy infringes on protected concerted activity, and therefore, if any employer has this policy in their handbook, they're committing an unfair labor practice. All right, that's the big picture. That's where we're heading today. So we have quite a few topics to cover. I'll tell you right at the outset that we will not spend a ton of time on any one particular topic. But if you have questions, please do go ahead and type that into the chat room or the chat area. If I don't see it, Luann will interrupt and ask the question. I am happy to answer questions as we go. So let's get started. On the federal level, here is what's going on. Last month, Congress passed and President Biden signed into law the Ending Forced Arbitration of Sexual Assault and Sexual Harassment Act. This is a direct result of the Me Too movement, the hashtag Me Too movement. This was a campaign promise by legislators as well as Biden. And they, sure enough, they went ahead and passed this law. This law makes it unlawful to require arbitration of sexual harassment claims. So in other words, if you have your employees sign arbitration agreements, and I know some of you do, some of you do not, but if you do, the current state of the law is that you cannot require an employee to arbitrate sexual harassment claims. The takeaway from this is if you currently have an arbitration agreement, I strongly recommend that you revise it, redistribute it out to your employees to carve out sexual harassment claims. By the way, it is okay under this new law to include a provision in your arbitration agreements saying that the employee can elect to arbitrate sexual harassment claims, but the decision is theirs, not yours as the employer. What do I think the impact of this is going to be? Well, I think that it will impact employers considerably. Obviously, the ones that have these arbitration agreements generally have agreements to keep these types of allegations confidential, out of the public court system where anybody can Google and find out the exact nature of what allegations are. I mean, the entire purpose of this act is to make sure that these allegations are brought in a public forum so that employers hopefully will be on better behavior in the future. I have an update regarding non-compete agreements as well, and many of you I know have non-compete agreements, and what I'm about to say should not chill you from continuing to use them, at least in the near term. However, be mindful that President Biden issued an executive order to the Fair Trade Commission last fall to curtail the use of non-compete agreements. The FTC has not acted on that executive order, but the reason it hasn't acted on it is because there have been vacancies at the commission that were only recently filled. Last month, the FTC indicated that they are in the exploratory phase of acting on the direction of the executive order. So don't be surprised if at some point in the not too distant future, you get an update from me or from Myra saying, hey, here's what the Fair Trade Commission is doing. And at this point, it's unknown whether they would say non-compete agreements are no longer enforceable period, or whether there might be some sort of limitation on them. In addition to the Fair Trade Commission, which is an executive agency, it's not a legislative body, Congress is also working on a bill called the Freedom to Compete Act. This is separate and apart from what the FTC is doing. The congressional bill would void all existing non-compete agreements and prohibit them going forward. Obviously, this is huge here in Florida. Florida is one of the most pro non-compete states in the union. It's very easy comparative to other states for employers in Florida to enforce non-compete agreements. But remember, federal law trumps state law. So if this act were to be signed into law, we would have to pretty much rewrite all non-compete agreements to exclude the true non-compete provision in there, and rather to buttress the non-solicitation provisions, meaning employees can still be barred from soliciting your customers, your clients, your patients, your employees, and you may still have confidentiality and non-disclosure requirements in an agreement. But if this law passes, and right now it's certainly on track within the next few months to pass, although it doesn't appear imminent, we'll need to readdress that. Now, there are some exemptions under the proposed bill. The exemptions are based on some of the Fair Labor Standards Act's white-collar exemptions. And remember, those are the executive exemption, the administrative exemption, professional exemption, outside sales, which would be exempt. You could still have a non-compete with an outside salesperson under the congressional bill. But we don't know what the Fair Trade Commission is going to say, whether the Fair Trade Commission will coordinate with Congress so that the two of them come out with similar declarations, or whether the Fair Trade Commission will just put a blanket prohibition on non-competes going forward. By the way, the National Labor Relations Board is also urging legislative action. I've cited a Supreme Court case, that's the SCOT, U.S. SCOTUS, Supreme Court of the United States, a few years ago came out with a decision called Epic Systems, in which the Supreme Court said arbitration agreements generally are enforceable. Recall, of course, from the high school social studies that how do you overturn a Supreme Court decision? Well, I guess the court can overturn it itself, but generally the way you overturn a Supreme Court decision is through legislation. Congress has to pass something. And so that's what we're seeing with the Freedom to Compete Act. The NLRB is urging legislative action, and the Fair Trade Commission is attempting to act unilaterally as well. What's the takeaway on this? Well, prepare to hear more in the upcoming months. I bring this up to everybody now so it's not a shock to the system. This doesn't come out of nowhere. If, June, July, or August, Myra or myself advise you that we've got a new law to deal with that prohibits non-competes. I would also strategically prepare for the likelihood that many non-compete agreements might become void and unenforceable. What do I mean by that? Well, let the top of the pyramid know. If your CEOs rely on non-compete agreements, you might put the bug in their ear that, hey, I attended a legal update on Thursday, and much to my surprise, found out that there's some legislation going through Congress that could bar non-compete agreements. We might want to dust ours off and take a look at what it says now and what we might want to do if this law passes. Do we want to continue with non-solicitation, non-disclosure, and confidentiality, or do we just want to rescind these agreements entirely? Some of you are covered by the Davis-Bacon Act. Many of you are not. I'm not going to spend more than a minute on this, but for those who are, there is a proposed rule from the Department of Labor that would amend the Davis-Bacon Act. So Davis-Bacon, for those who don't know, generally speaking, requires that employers pay the prevailing wage to employees working on certain federal projects, where they're either the direct subcontractor to the federal government or a contractor to a contractor to the federal government. And generally speaking, what the proposed rule would do is expand the definition of things like building and work, which are the types of things covered by Davis-Bacon, to include solar panels, wind turbines, broadband installation, electric car charger installation, and to cover construction activity, even if it's only on a portion of a building. I say that the DOL is proposing a rule. By law, they have to give the public the opportunity to comment on a proposed rule change of at least 60 days. And that public comment period ends in May of 2022. If you are so inclined to write to the Department of Labor saying, I think this is a terrible idea, feel free to do so. That is your right, but you only have until May 2022. The takeaway from this is if you are covered by Davis-Bacon and you work on these types of projects, you might need to prepare for some labor budget flexibility in the second half of 2022. That is likely when these changes would go into effect. The change being you might now have to pay a prevailing wage rate to employees, which is more often than not considerably higher than what you ordinarily would pay for that labor. I mentioned that we would talk about the Build Back Better legislation. The legislation stalled out late last year, did not pass. It was in the news. So I think probably everybody is aware that this legislation did not go through in its primary iteration, which was a ginormous bill packed with all sorts of provisions. And I believe it was Senator Manchin out of West Virginia said he would not vote for it, and that's what killed it. Since then, Congress has been introducing bills that would enact Build Back Better on a piecemeal basis. So they're kind of implementing one thing at a time. Here are these under the radar employment law provisions that you probably did not hear about. These were not in the news other than the employment law newsletters that people like me read. The Build Back Better legislation would add new civil penalties, meaning fines, monetary fines, for unfair labor practices committed by employers. Remember, it's an unfair labor practice to have an unlawful handbook policy. What are these new civil penalties? Well, they would be $50,000 for each violation. So if you have 3 unlawful policies in your handbook, $150,000. The penalty is increased to $100,000 if the violation results in serious economic harm to an employee if the employer had a similar violation in the previous 5 years. So if it turns out, lo and behold, you had an unlawful handbook policy 5 years ago and now you've got another one, you fire an employee for violating that unlawful handbook policy, you could be on the hook for $100,000. All right, that's the bad news. Now let me give you the worse news. The Build Back Better Act would also provide for personal liability for those civil penalties for any company officer or director who directs or commits a violation, who establishes the policy that led to the violation, or who had actual or constructive knowledge of the events and the authority to prevent the unfair labor practice, but did not do so. These are pretty substantial fines, $50,000 even for an unknowing violation. You know, intent is not part of this civil penalty. $100,000 if this is a repeat offense here. So the takeaway on this is just continue to monitor. I don't believe this is imminent. I don't believe that this will be passed within the next month or even 2 months. However, as we get closer to the midterm elections in November, be mindful of this. I predict there will be an onslaught of legislation that Congress will attempt to pass before November, but it might be right up until November that they really start working. All right, let me now go into the Florida legislative update. To recap what happened in 2021, well, last March, the Florida legislature passed the COVID-19 Business Immunity Act. This was great from the viewpoint of most employers. It provided that employers would enjoy civil immunity, meaning they could not be sued by people claiming I got COVID as a result of visiting your workplace or working for you, if the business made a good faith effort to substantially comply with public health standards. The times are changing, as they say. No longer are we seeing such protections for the business community. Rather, what we're starting to see out of the Florida legislature would be penalties for employers who don't go along with what the legislature wants. We first started seeing this in November with the rules regarding vaccination mandates. For those who don't remember what that law was all about, it essentially prohibited employers from mandating vaccinations without providing numerous opt-out provisions or exemptions. And it was, and still is, extremely easy to meet one or more of the 5 exemptions that the legislature set forth in this particular act. And for those of you who are covered by CMS, the Center for Medicare and Medicaid Services, you're probably aware that there is a federal requirement that employees be vaccinated. And I will tell you, it's impossible for employers in Florida to comply with both the CMS mandate, which was upheld by the US Supreme Court, while simultaneously complying with this Florida law prohibiting vaccination mandates. So that's the dilemma that employers find themselves in. So with that kind of backdrop, seeing how the legislature is moving away from being a business-friendly entity, which it historically has been, we now are looking at House Bill 7, which has passed both chambers of the legislature. It is on Governor DeSantis's desk. He will likely sign it any day now. House Bill 7 is also known as the Stop Woke Act, which you probably at least tangentially heard about in the news. It's national news, frankly. This particular bill would prohibit private employers from discussing certain things in their diversity training. There are 8 of them. I'm not going to read them to you, but I'm happy to share the PowerPoint if anybody wants to get the rundown here. Many of the things are not likely to come up in diversity training. You know, I do a fair share of diversity training. I don't think that I have ever discussed the topic of members of one race, color, sex, or national origin being morally superior to members of another race, color, sex, or national origin. However, there are a few things that give me some concern here as somebody who conducts diversity training on a regular basis. And some of those things might be number 6, an individual by virtue of his race, color, sex, or national origin should be discriminated against or receive adverse treatment to achieve diversity, equity, or inclusion. Well, this is kind of the same concept here as, but phrased in a different way, of discussing federal affirmative action concepts or federal contract preferences for women-owned businesses or minority businesses. You know, does this mean that if that topic were to come up, if somebody were to ask a question about that during diversity training, it's now against the law to discuss it? I have some apprehension about that. But here's the entire list of the 8 things that cannot be discussed in diversity training. So the takeaway from all of this is, well, number 1, monitor the news. It will be, you know, front page of the Orlando Sentinel. It'll be in national publications once this bill is signed. But if you conduct diversity training, whether it's internal or through a third party, be sure to review the diversity training materials to ensure that you are not violating the act. Let me shift gears now and move away from legislative action and give you an update on executive agencies like the EEOC, the Equal Employment Opportunity Commission, the National Labor Relations Board, and the Wage and Hour Division. First, last month, the EEOC issued some technical guidance on COVID-19. If you have been on the EEOC's website, or if you have received a link from me, because I've emailed it to many of you, you're aware that there's kind of a frequently asked questions page that the EEOC has and that it updates from time to time. This is what we're talking about here. They issued a new FAQ page, which largely repackages the previous guidance from 2020 and 2021. You know, things like, do I need to give a reasonable accommodation to an employee who has long-term COVID? And basically, the analysis the EEOC gives you on that FAQ page is the same analysis you would get if you were dealing with a accommodation request from somebody with any other condition. It really isn't a game changer, but it does provide some occasional helpful information. Here's what's new. The EEOC has come out with guidance on pandemic-related caregiver discrimination. Primarily traditional discrimination principles apply. And what the EEOC is doing here is, again, reminding all of us to use the traditional discrimination analysis or framework when addressing COVID-related and specifically pandemic-related caregiver requests for accommodation. The examples that the EEOC gives would be, for example, if an employer provides flexibility such as telework or modified schedules to employees with school-aged children due to school closures or distance learning during the pandemic, you're free to do so as long as you're not treating employees differently based on sex or gender-based assumptions, meaning you can't assume that, for example, a female employee might have a greater need to take time off. And kind of the inverse of that is you can't treat women more favorably by giving them more time off than a male employee who requests time off to care for the children whose school is closed or have to engage in distance learning. Gender-based assumptions about who may have caregiving responsibilities are prohibited by the EEOC. Now, by the way, this is reminiscent of the EEOC's position on pregnancy or maternity leave, or paternity leave for that matter. For those who aren't aware of this, it's worth reviewing just so you are aware of it going forward. It is unlawful to treat females differently from males when it comes to post-birth bonding leave. You know, there are basically two types of maternity leave, although we generally lump them together. One would be a medical related leave, you know, to allow the mother to recuperate from childbirth. But the other component of maternity leave is to bond with the child. So in other words, the mother has recovered from giving birth and now has some time off in order to care for and bond with the child. Well, if the father asks you to take time off to bond with the child, the EEOC's position is you need to give the father the same amount of bonding leave that you provide to the mother or a mother. So what are employers supposed to do? Well, they're supposed to figure out, okay, well, how much of this maternity leave, let's say you give 12 weeks, is for medical recuperation? And the answer could be different from time to time, but 2 weeks, 3 weeks, 4 weeks, I don't know, is probably something in that ballpark. The remainder of the 12 weeks, so let's just say it's 8 weeks that you provide for maternity leave, you must also offer to fathers to bond with the child. So it may or may not be news to some people. I occasionally will review a handbook and see a maternity leave policy and paternity leave policy that does not comply with that. For example, mothers get 12 weeks, but fathers can only have 2. That would be problematic. All right, excuse me for a second here. Going back to the caregivers of persons with COVID-19, the EEOC reminds us in the new technical guidance that associational disability is prohibited, just like you can't refuse to hire an employee who's associated with a person with a disability, such as an applicant whose spouse has a disability, and you're concerned, well, this person's going to miss work because they've got to care for this person's disability, take them to doctor's appointments, help them with their daily tasks, etc. Likewise, you can't discriminate based on somebody's association with a person who either has long-term COVID, who has a medical condition that could be exacerbated by COVID, etc. The EEOC tells us employers may not discriminate against workers based on stereotypes or assumptions about workers' caregiving responsibilities for an individual with a disability, such as a child, spouse, or parent. So what is the takeaway on the EEOC's technical guidance? Frankly, I just want you to be aware of it. I want you to be aware that the issues that the EEOC is currently giving us guidance on have to do not so much with employees who need to miss work because they have COVID. We've got the guidance there from the EEOC already, but rather the EEOC is now monitoring caregivers and how the caregivers are being treated and whether they're being discriminated against. All right, moving on to the National Labor Relations Board and the Equal Employment Opportunity Commission. You may not be familiar with the term memorandum of understanding. A memorandum of understanding is nothing more than an agreement between two agencies, And they could be federal agencies, it could be one federal and one state agency, it could be two state agencies. But the agreement is that they will share information with each other. They will also train each other's investigators regarding the basics of what to be on the lookout for. The EEOC, which investigates claims of discrimination based on sex, race, national origin, age, disability, religion, etc., and the NLRB, which investigates claims of discrimination for engaging in protected concerted activities, have gotten together, signed a memorandum of understanding. They have begun training each other. As a matter of fact, they are also providing webinars to the public regarding the two agencies' joint functions. I attended one a week or two ago, and frankly, it scared me a little bit because many employers have dealt with the EEOC at some point. Very few employers have dealt with the NLRB. The NLRB's jurisdiction is far broader than the EEOC's. The EEOC is limited to looking at claims of disability based on a protected characteristic or retaliation for bringing a claim of discrimination. The world of protected concerted activity, however, is huge. It is a much larger universe than what the EEOC looks at. And very frequently, the EEOC will dismiss a charge of discrimination, saying, yeah, what you alleged isn't a violation of the laws that it investigates, Title VII, Age Discrimination in Employment Act, Americans with Disabilities Act, but very well might constitute a violation of the National Labor Relations Act, the NLRA, which is the law that provides protection for concerted activities. So currently, there are memos of understanding among the EEOC and the Department of Justice and the OFCCP, which is the Office of Federal Contract Compliance. There's a memo of understanding between the Wage and Hour Division and the IRS, meaning, in other words, if the Wage and Hour Division finds out that you're misclassifying a worker as an independent contractor when really they're an employee, they're going to go tell the IRS, and you're about to get an audit there too, because you're probably not taking out the taxes correctly from that independent contractor that you've misclassified. So what's the likely effect on the newest memorandum of understanding between the NLRB and the EEOC? I would expect that many times when you receive an EEOC charge, you may also receive an NLRB charge, and now you'll have to litigate the same basic allegations in two different forums. In my experience, the NLRB is a far more employee-friendly forum than the EEOC. You know, most EEOC charges end up getting dismissed with no finding. You know, the EEOC says we're unable to conclude whether anything here establishes a violation of the statutes. The NLRB, on the other hand, finds violations all the time. And the penalties for violating the NLRA currently include reinstating the employee, providing back pay to them for whatever compensation they missed out on because they were fired, as well as posting in a conspicuous place a notice saying we violated the National Labor Relations Act, and employees, if you feel like your rights have been violated, here's their telephone number, here's the website to go on. So I hate being the bearer of bad news, but that's what's coming down the pike. Let me now jump into the National Labor Relations Board and what it has been up to. To provide a brief overview as to the history of how the NLRB works, I'm reminded of a quote by Supreme Court Justice Amy Coney Barrett, who was speaking to the Federalist Society not too long after she was sworn in as a Supreme Court Justice, where she made a statement that Supreme Court justices can't be seen as partisan hacks who are willing to overturn policies based on the makeup of the court. And I think that's a fine statement. Being an officer of the court, that's exactly what we want to hear from our Supreme Court justices as well as any judge. The NLRB, on the other hand, seems to take the opposite approach. It will reverse decisions of the previous board as soon as a new administration comes into the White House. And I'm not trying to make this political at all. Both parties do it. it should be no surprise that currently, a year and a half into a new administration, we're starting to see this more and more. And specifically, what the NLRB makes very public is the fact that they are trying to change the joint employer standard. They're trying to change the independent contractor requirements, and they are trying to expand the scope of what constitutes protected concerted activity. To talk about each of those somewhat briefly, the reason this matters is because a joint employer finding makes both the company that is using somebody else's employees as well as that traditional employer both liable for each other's violations. If you have ever been with me while defending against a Department of Labor audit for your wage and hour practices, you will know that this is one of the first things the investigator will tell you during the investigation. If you use a staffing company's employees and you think that you're not their employer, that the staffing company is the one that's responsible for making sure they get paid at least minimum wage and overtime, you are likely mistaken. You are probably a joint employer. If you exercise really any degree of control or even have the ability to exercise control, you are likely a joint employer. Excuse me. That was the standard for many years prior to the 2010s. Joint employer findings occurred only when the user exercised control over the supplier's employees. So you bring in the employees from a staffing company, but they report to your supervisor, they're also your employees. You're a joint employer. In 2015, the board increased the scope of joint employer status. The board said that you'll be a joint employer even if you have indirect, not direct control, but indirect, or the unexercised right of control. So in other words, if theoretically, but not in reality, you have the ability to tell the supplier company, the staffing company, don't send John, we don't want him working here anymore. If you theoretically had the ability to tell John how to take the garbage out, you would be a joint employer. In 2020, though, that changed. The NLRB came out with a rule, not a case, but a rule saying that the user must have direct and immediate control to be considered a joint employer. This narrowed the scope of joint employer findings significantly. In fact, it narrowed it even beyond how narrow it was in the decades prior to the 2010s. So here's the update. The National Labor Relations Board announced that it will revisit this joint employer standard in its 2022 regulatory agenda. We are going to see a proposed rule in the next couple of months where the NLRB proposes that we go back to the 2015 standard. The takeaway for this, if your question is, well, Keith, what do we care? The answer is, if your company uses staffing companies or other third parties to supply labor, you might want to be aware that despite a small respite since 2022, where you might have been off the hook for the other company's labor violations, wage and hour violations, discrimination violations, etc., you may now be back on the hook. What can you do about it? Well, my best advice is take a look at whatever agreement you have between the staffing company and yourself. Although the agreements probably say the staffing company is responsible for wage and hour compliance, etc., those provisions generally mean nothing once you find yourself hauled into court or the subject of a wage and hour audit by the Department of Labor. What you do want to see in those agreements would be statements such as the supplier, the staffing company, has the sole right to manage the employees. The user company, your company, does not. Basically, you will accept whoever they give you. You're not telling them how to do the work. They report to the staffing company's supervisors. Those types of things would help you if you're trying to avoid a joint employer finding. Excuse me. When it comes to independent contractors, here's the issue. The issue is if you misclassify a worker as an independent contractor, you can find yourself in trouble with the Wage and Hour Division. You can find yourself in trouble with the National Labor Relations Board. You can find yourself in trouble with the IRS because you're not taking out their taxes properly. Historically, employers and courts have looked to a fairly old Supreme Court decision, the NLRB versus United Insurance Company of America, which set forth 10 factors to determine whether or not a worker was an independent contractor or an employee. Over the years, there has been shifting focus on those particular factors, which factors should count more than others. And the two most common factors that the importance has shifted between have been control. Does the employer have the ability to control the independent contractor's work? Or on the other hand, sometimes a more important factor is whether the worker has significant entrepreneurial opportunity for gain or loss. Can they make more money based on how they decide to do the work or not? And in 2014, the NLRB came forth with a decision that emphasized control. Look at the actual, but not theoretical, entrepreneurial opportunity. Look at constraints imposed by the employer. Look at whether the worker is in fact rendering the services of an independent business. That changed in 2019. The NLRB overturned the previous decision and says, hey, these factors have to be looked at through the lens of entrepreneurial opportunity. So generally speaking, the rationale was to make it easier for employers to classify workers as independent contractors, basically by saying, well, if the worker works harder, they can make more money. Therefore, they're an independent contractor. You may or may not agree with the rationale of how we get from point A to point B there. The intended effect, by the way, of the 2014 decision, which was during Obama's administration, was attempting to make an employee finding more common if there was a dispute about classification. The Trump NLRB attempted to make independent contractor findings more common. Interestingly enough, the actual effect was the opposite. More workers were classified as independent contractors under the 2014 standard, and under the 2019 standard, it was more common. I'm sorry, I think I got that backwards. More common for independent contractors after 2014, more common after 2019 for workers to be found to be employees rather than independent contractors. But that may shift again. You know, the NLRB has signaled that it is looking to overturn the 2019 decision. It has asked for public comment about whether the board should re-implement the 2014 standard. Just so you know, you may have heard of this, the Department of Labor, which is a different agency, issued a final rule under the Trump administration clarifying when workers are independent contractors. Again, it's a more employer-friendly standard, makes it easier for employers to classify workers as independent contractors. The Biden administration came in and immediately announced it was withdrawing the Trump rule, which would make it easier for independent contractors to be found. And just within the last week, a district court in the Eastern District of Texas ruled that the Biden administration's actions violated the Administrative Procedures Act, and it left the Trump rule in place for the moment. That could change in the coming months. What's the takeaway on this? If you use independent contractors, you should monitor developments. Myra or I will give you an update if and when there's a change that you need to know about, but be mindful. This is something that is likely coming down the pike if you use independent contractors. Also, remember, the NLRB, the EEOC, the Wage and Hour Division, the IRS all share their findings. So if one of them finds that you're misclassifying independent contractors, the other three are likely going to be coming after you as well. I will conclude by discussing protected concerted activity, everybody's favorite topic, because the NLRB has signaled that they are looking to expand the scope of employee protections. What is protected concerted activity? Well, it's protected by the National Labor Relations Act, specifically Section 7 of that act. Conduct is protected if it pertains to any terms or conditions of employment. So if employees want to discuss their pay, or unsafe work conditions, or work hours, or benefits, or management style, that's all protected. Not all conduct that's protected, though, is protected concerted activity, which is what we're concerned about here. Activity is concerted if it is engaged in by two or more employees. So employees discussing their compensation among each other, that's protected, that's concerted. One employee going to the boss and saying, "You're not paying me enough," might be protected, but it's not concerted. It's not protected concerted activity under Title VII. If you want to fire somebody for complaining they're not paid enough, but they're only bringing that concern on behalf of themselves, not on behalf of others, that's perfectly fine. That's not a violation of somebody's protected concerted activity rights. Concerted activity can also be taken by a single employee on behalf of others, or if they're trying to induce group action, or if they're trying to prepare for group action. Be mindful that this law applies equally to both unionized and non-unionized workplaces. The vast majority of the National Labor Relations Act applies to unions and unionized workplaces. This section, however, applies to non-unionized workplaces as well. And I will tell you the rules pertaining to protected concerted activity are very counterintuitive. It is not like a discrimination analysis where things somewhat make logical sense. Unfair labor practice charges and unfair handbook policies make employers scratch their heads. You know, how could the National Labor Relations Board find that this is unlawful for me to do? Excuse me for a minute here. I'm going to mute myself. Be right back. Excuse me, thank you. This slide is to illustrate how issues arise when it comes to unfair labor practices. Number one, you might be subjected to an NLRB investigation. They investigate unfair labor practice charges. If, for example, you fire an employee for engaging in protected concerted activity, the NLRB might come around and ask you why you did that. It might order you to reinstate the employee. It might order you to provide back pay. And remember, post that nice little notice saying we violated the law, here's how you can sue us. Additionally, the NLRB reviews handbook policies and declares them to be lawful or unlawful. For example, the textbook illustration of an unlawful policy would be one that says your compensation is confidential, discussing your pay with others is grounds for immediate termination. Merely having that policy is illegal. You could be subjected to fines, and remember, the Build Back Better legislation could increase fines to $50,000 for having a policy like that. So in the context of unfair labor practice charges, meaning I'm being brought before the NLRB, I'm accused of firing somebody illegally for engaging in protected concerted activity. The recent history is that under Trump, the NLRB narrowed what would be considered concerted activity. So for example, an employee who got up during a group meeting and said, I think the company is racist, who's with me here? Prior to the Trump administration, that was protected concerted activity. In this case, Allstate, not Allstate, Allstate Maintenance, though, where this exact fact pattern played out, the board steered away from prior precedent and said, well, hey, just because somebody makes a statement during a group meeting with other employees, that doesn't automatically make their conduct concerted. So sorry, employee who piped up that you felt the company was discriminating, but you're not protected under the law. The company did not commit an unfair labor practice by firing you. Under Biden, the NLRB has announced that they are trying to change this standard. They are attempting to make the new standard to protect any discussions among employees of certain subject areas and have them be considered inherently concerted or intended to induce group action, such as this very scenario that played out in the Allstate Maintenance case. Discussions of race and national origin discrimination, according to the board, are inherently concerted. Now, if you're like me, your radar's probably going off, wait a minute, doesn't this sound like something the EEOC would investigate? It sure does. But remember, the NLRB is a far more employee-friendly forum than the EEOC. You may find yourself having to litigate with both the EEOC and the NLRB, and the outcome with the NLRB might be significantly different. So to go into what these inherently concerted subject matters are, here's the list that the board has given us. Discussions regarding safety, discussions regarding discrimination, discussions regarding wages or job security or changes in work schedule. Under the Biden NLRB will automatically be considered concerted. So the takeaway on this The likely impact is that the board is more likely to find unfair labor practices, even when the employee appears to act on behalf of him or herself only. The NLRB is more likely to initiate investigations in light of that memo of understanding. And if you have had no prior dealings with the NLRB and have previously felt like the NLRB is nothing to worry about, change is coming. We will start to see the board becoming more and more active, particularly here in Florida, where we are covered by Region 12 out of Tampa. I'm going to finish by discussing handbooks. You may recall, 5-6 years ago, during these types of legal updates, I would tell you, here are policies that the board has recently found to be unlawful. And many times, you and I were astonished that seemingly perfectly okay handbook policies were found by the board to be unlawful. The reason why is because the legal standard for many years has been the following. If an employer maintains a neutral handbook policy, meaning one that doesn't obviously infringe on protected concerted activities, that handbook rule is still unlawful if employees could reasonably construe the rule to prohibit protected concerted activity. Under the Obama administration, the NLRB frequently would declare handbook policies unlawful based on hypothetical or theoretical conclusions that employees could construe the rules to prohibit protected concerted activities. For example, social media policies, no cameras in the workplace policies, use of computer systems policies. You may remember going back several years ago, I probably provided you with sample policies that would be okay under the Obama NLRB because they would change so frequently. Under President Trump in 2017, the NLRB completely scrapped that framework. They overruled the previous standard as to when handbook policies would be declared unlawful. They came out with 3 categories as follows. Basically, category number 1 would consist of handbook rules that require employees to abide by basic standards of civility. Those policies generally are lawful. For example, if you have a no camera in the workplace policy, that's just a basic standard of civility. We don't want you filming other employees without their knowledge. We don't want you taking pictures of trade secrets or anything like that. Whereas under the Obama NLRB, that type of rule was unlawful. The rationale being employees should have the ability to take pictures of unsafe work conditions. Under Trump, that changes. Under the NLRB, under Trump, again, category number 2 was that there are some rules which are on the fence. They kind of look like they might impinge on Section 7 rights. We'll take a look at those on a rule-by-rule basis. And then number 3, there are some policies that are just clear-cut violations of protected concerted activity rights, such as you can't discuss compensation with your coworkers. Those are unlawful. Under Biden, guess what? The NLRB has announced that they are seeking to overturn that Boeing decision that came forth with these 3 factors. The board wants to go back to the old standard, which is if any employee could even hypothetically think that this prohibits them from engaging in protected concerted activity, the rule is unlawful. And specifically, the types of policies that the NLRB is going after would be confidentiality policies, non-disparagement policies, social media policies, media communications, meaning, if you prohibit your employees from talking to the media, that will likely be found unlawful under the Biden administration. Civility policies, respect and professionalism policies, policies that prohibit offensive language in the workplace, and no camera policies are going to be fair game. We will likely see some significant changes in what the board says is permissible versus impermissible. So the takeaway is be prepared to hear Keith at the next update in April go over various policies that the board has declared to be unlawful. And naturally, Myra and I will keep you apprised of those as they happen as well. So hearing that my voice is giving out on me, fortunately, we've come to the end of today's update, and I am more than happy to answer any questions that anybody might have. I've not been monitoring the chat box. If we have questions there, Lou Ann, please go ahead and let me know, and I'm happy to answer any questions.
We actually do not have any questions currently.
Hooray! Well, if you do, feel free to reach out to me. You likely have my email address. If you don't, email Myra. She will get a hold of me. I'm happy to answer whatever questions you might have. Let me thank everybody for their time. Myra, I will turn things back over to you at this point. Again, everybody, thank you for being with us this morning.
Thank you, Keith. Great information. Thank you, everyone, for attending. As mentioned, we're recording the presentation, so we will share that with everyone later on today. Have a great week. Keith, thanks again for powering through for us. I truly appreciate it.
Thank you.
Thanks.